Hello everybody, welcome to my channel. We'll continue on talking about the series of posts about custody disagreements and how to communicate with the other parent. After a couple decides to split, separate, or divorce, the custody battles becomes extremely painful, even unbearable. Previously, it was posted that a former couple, Mr. Jones and Miss Jones, was ordered to communicate about their children solely using Our Family Wizard OFW app. It was shared that Mr. Jones sent a message via OFW to inform Miss Jones that someone from OFW would contact her and walk her through the process for her to have access. We explored some of the possible reasons in that post to make sense of why Mr. Jones had chosen to message Miss Jones on an app in which she didn't have access to. The message about OFW access was sent to Miss Jones on November 1st, 2021. It was concluded that Mr. Jones wanted to comply with the court decision and prevent further accusations of harassment by Miss Jones. However, OFW was the wrong platform to use for this particular message. You can refer to our previous video to have the full message. The court adjourned on 28 October 2021 as stated on the previous post. The email below is a message sent by Mr. Jones to Miss Jones 2 days after the first message was sent on OFW. Mr. Jones sent this message to Miss Jones's personal email account. Let's go over the email starting with the format. Mr. Jones was guided by his lawyer of the time to use this template for communication before the court reached a decision and ordered both parties to use the OFW app. The first part is the timestamp from the email, and then Mr. Jones typed the dates of his visit with his children. He mistyped the 29 October as 9 October. We know it is mistyped because he corrected it in the next section. On Wednesday, November 3, 2021 at 10:54 a.m., Mr. Jones wrote 9 October Friday, 02 Tuesday, November 21. In the next section, Mr. Jones states something positive that happened while the children were with me. Friday, 29 October 2021, met children at post office, completed and submitted passport renewal applications, ensuring son and daughter expired passports were submitted for renewal. We were very happy and excited to see each other. Saturday, 30 October 2021, did trunk or treat events, took pictures, and ate a lot of candy in Aberdeen, Bel Air, and Havre de Grace, which featured a hayride. Son and daughter had a great time and received a lot of candy. Sunday and Monday, we played singles and team matches ping pong in Aberdeen Proving Ground, Guest House, and daughter beat daddy in ping pong. Son got a haircut he really likes and is very happy with. This is an indication of a good communication when this much detail is shared with the other parent, and also is a sign of good co-parenting. However, we know that this former couple has a strained relationship. We know this because they had been ordered to use a court app to communicate with each other. That said, the last two brief paragraphs focus on the pleasant activities they participated together, but the first paragraph seems to be out of place. Mr. Jones states that they met in a post office and completed an application for their children's passport. Children's passports had been expired since 2018, and in 2019, Mr. Jones left the country with children's passports. He continuously refused to renew children's passports until 29 October 2021 court order. Clearly, the first statement is not for Miss Jones because she was in the post office with them. Mr. Jones was documenting that he complied with the court order. However, since the passports were already submitted, this statement serves no purpose. Ordered that Mr. Jones shall provide Miss Jones with the children's passports. Both parties shall fully cooperate in renewing the children's passports, and Miss Jones shall retain possession of the children's passports when the children are not otherwise traveling. The next section is generic about medical issues. Mr. Jones mentions there was medicine son had to take and took it successfully. Medical issues. No medical issues. Our son took all of his prescribed medication, ferrous sulfate, iron supplement. The last dose taken at 800 hours prior to breakfast on 02 Tuesday 2021. The next section points out to an effort by Mr. Jones to document his claim of isolation. School-related issues. NA, November 1, 2, Monday and Tuesday. Parent-teacher conferences. Please ensure I am added to the emergency school contact list. Mr. Jones, CMR, Cal, email. His reference to parent-teacher conferences showed that he was informed of the conferences and manifested some interest in children's schooling. Since he was in town these specific days, he could have attended the parent-teacher conferences. There's no mention of his attendance in this section. Mr. Jones adds that his wish to be added to the emergency school contact list. Emergency lists consist of trusted family and friends and cannot be the parent. This statement makes very little to no sense. In the next sections, there isn't anything that stands out. Regularly scheduled weekly activities, NA. Sibling peer relationships, no change in relationship behavior. The diet 29 October 2021, 02 Tuesday is good. They had a great appetite and they ate their favorite food. were very excited to be with Daddy, 29 October to November. On the day of departure, son and daughter were very sad. Daughter cried and stated she misses Daddy. Son asked when Daddy will return to Germany and when can he visit. We all stated we love each other. Daddy comforted both, then drove home, missing them so much. Schedules change, request NA, discipline NA, no discipline issues. Although this was an unnecessary email, it was put together well. For the most, if Mr. Jones was trying to document a positive picture of his relationship with their children, he accomplished his goal in this email. However, there is one issue. He was ordered to use OFW to communicate with Miss Jones for all communications about their children except during emergencies. This email had no indication of any kind of emergency. It is not clear what prompted Mr. Jones to send an email about their children to Miss Jones' personal email, while a couple of days earlier he sent an email unrelated to their children via OFW. It is important to state only a judge can determine if an action is a contempt of court. However, this email is potentially a contempt of court. Although a well-written email, it is on the wrong platform. Thus, Miss Jones could have used it to sue Mr. Jones for a contempt of court. On October 29, 2021, court ordered that the parties shall both use the Close app or the Our Family Wizard OFW app should Mr. Jones pay for the cost for both parties to use the OFW app for all non-emergency communications regarding the children. Additionally, the parties shall use the OFW, the Office of Family Court Services email protocol as a basis for their communications in the Close or OFW app. Mr. Jones could have used this email as an opportunity to inform Miss Jones about his purchase of OFW for both of them. For unknown reasons, Mr. Jones didn't mention OFW and didn't use OFW. As advised before drafting an email to the other parent, determine the purpose of your email. Then choose the right platform. Is the email about your children or about an issue between you and the other parent? If it is about your children, use OFW. If it is about something else, use other platform. Always stay at point, and no matter what or how you feel at the moment, be clear and concise. Here's the $1,000,000 question. If you were Miss Jones, would you sue Mr. Jones for a contempt of court for violating the court order?